Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Southport Magistrates Court. Client was charged with what's called driving over the zero limit but under the general limit whilst in control of a truck. So basically what that means is when you drive a truck, you're expected to maintain a blood alcohol concentration of 0. If you get caught between 0 and 0.05, you get charged with over the 0 but under the general. So you're basically like a P-plater, so you've got to maintain 0, and if you get caught with any alcohol in your system whatsoever, you get charged with that offence. My client was found to have a blood alcohol concentration of 0.038. So had he been in a car, he wouldn't have been over the limit. Because he was in control of a truck, which carries 0, he was over the limit. A couple of things. Worst case scenario with no history in the last 5 years is a 9-month loss of licence. Mandatory minimum is 3 months. That applies to anyone to whom a 0 blood alcohol concentration applies. So P-platers, etc., and truck drivers. So if you're in a truck, you've got to be 0. If you've got any alcohol, you're looking at 3 to 9 months. Like P-platers, you cannot apply for a work licence if you're charged with this offence. To be eligible to apply for a DUI drink driving work licence, you must be the holder of an open Queensland licence, which my client was, but you also can't have been driving a vehicle to which a 0 blood alcohol concentration applies when intercepted. So because he was driving a truck which carries a permissible blood alcohol concentration of 0, he was not eligible to apply for a DUI drink driving work licence. So penalty range, as I said, 3 to 9 months. My job was one of getting the disqualification down as low as possible, being 3 months. A couple of things compounding the matter. He had a previous, so it was a repeat offence, previous offence of 0.084, but it was outside of the last 5 years, so that didn't aggravate the penalty range. Just to put that in perspective, if someone's got previous drink driving offending within the 5 years leading up to the offence, the mandatory minimums and maximum penalties are aggravated. I won't go into that now, given that this was outside of 5 years, but that's just something to note moving forward. Obviously, the fact that he was driving a truck aggravated the matter, but there was actually a collision. So my client was merging and collided with all things a Mercedes. So that Mercedes was written off. I don't want to overstate the matter. It wasn't a brand new Mercedes, it was quite old, but the damage was such that it was deemed a write-off. So in any event, so reading a 0.038, previous 0.084, albeit outside of the last 5 years, driving a truck with collision. Again, worst case 9 months, mandatory minimum 3 months, and my job was obviously one of pushing for the mandatory minimum or something close to it. Given the the circumstances of the offence, I got my client to do more than just the regular reformatory course that we get our clients to do. I basically got him to do all of them. So he did a number of courses that exposed him to what could have gone wrong beyond that which did. I mean, as much as there was a car written off, there was no one injured, which was great, no fatalities, etc. And obviously he wasn't hurt. I got him to get character references based on the same template we give all of our clients. It guides the referees through who it's going to be addressed to, the key points they've got to cover, etc. I drafted affidavit materials up based on what my client told me he'd learned from the courses, explaining to the magistrate, in fact, what he'd learned. I made detailed verbal submissions to the magistrate about my client's work history, what he does, why he needs it. I mean, it goes without saying he's a truck driver, he needs his licence to do it, but the fact that he's literally going to be unemployed while he's off the road, difficulties he and his family are going to suffer. So he's married, young kids, heavily mortgaged. His wife does work, but her income alone is not enough to keep him going long term. So again, my job was to try and persuade the magistrate to give something close to the minimum of 3 months, notwithstanding those aggravating factors, as I said, being the fact that it's a truck and the fact that there was a collision. Look, the short version is, I did speak at length, but the short version is I was ultimately successful. So I was successful in persuading the magistrate not to go past the mandatory minimum 3 months. So my client was disqualified for 3 months. He was given a modest fine, and that's it. So it was physically impossible to get any better an outcome than that. So he got the mandatory minimum 3 months. So basically he's just going to have to, take it easy for 3 months. But in 3 months' time, he'll get his licence back, and he'll be back in action as if it never happened. So notwithstanding the fact that he's off the road for a little bit, given that it's the mandatory minimum, the absolute best possible outcome, he's relieved. I'm Andrew Wiseman. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment, or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I'll look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road. Does your license need saving? Do the wise thing.